Welcome to Aging Insight with your host, John Ross and Lisa Scholmeyer. This program is made possible by
Well, hey everyone, welcome to another edition of Aging Insight. I'm Lisa Scholmeyer, and I'm here with John Ross. And John and I are elder law attorneys right here in the viewing area of KLFI. We bring the program Aging Insight to you because we want to educate you, without the pressure of being in a law office, John. Sometimes when people hear attorney or lawyer, it makes them a little nervous.
Well, I used to say that, a lot of times when somebody came in to meet me for the first time was the only time they had ever actually visited or met with a lawyer. Their whole concept of attorney was Perry Mason or Matlock.
Right, yeah. So
I don't know, maybe people don't remember Perry Mason. I may have to update it a bit, I don't know.
Well, so we bring Aging Insight to you so that you can get some information about legal issues that you may face as a senior adult. And, John, I tell people all the time that life doesn't get simpler when you retire. Frankly, I think it gets a little bit more complex.
Yeah, it certainly can. And so we like to try to address as many of these issues as we can come up with on this show that we bring to you just about every week. And that way, maybe within all of these, we'll have hit something that's important to you along the way. We of course, we have lots of folks that have come into the office because they watch the show, and
and we appreciate when you tell us that.
Yeah, it's always, so if you see us at Sam's on a Sunday, when we're grocery shopping. So anyway, I think one thing that I get a lot of is people coming in wanting to know how they'll say something like, "I need to get my house in my name."
Right. Yeah. No.
Or I need to get Mama's house out of Mama's name to somebody else's name.
Right.
But there's all these kind of transferring issues that people are worried about, and sometimes it's really simple and sometimes it's a giant pain in the rear.
Right. So what we're going to talk about today is clearing title to property. And John, we recently did an episode about passing your home to your heirs and beneficiaries, but now we're talking about maybe someone has passed away and nothing was ever done at the time. Maybe it's your spouse who has passed, and all of your friends keep telling you need to get title into your name. So when it comes to dealing with real estate, nothing is rarely as simple as you would think on the front end, because when it comes to real estate title, like my dad used to say, they don't make any more of that dirt out there. So title to real estate is a very unique type of asset, and so we have lots of processes in place to make sure that we have the correct name on the title, that if the bank loans you money against that property, that everything is documented properly. So real estate title is a very important asset, but it's also a very technical asset to make sure that you own and possess. And when someone dies or something is passed through the family, it can become even more complicated. And so you need to take care of it rather than letting it slide by. So, John, because we have faced so many issues with passing title to real estate property, I thought today would be a great episode to share some of our experiences, and maybe our viewers can, I bet someone's going to say, "Oh, yep, that was my family."
Yeah, no, that's probably right. And I can give you a very real life example of how this can really go wrong over time. I had a lady come to the office, this was years ago, but she came in, and this particular woman was in her 90s, and she came in saying that what she wanted was to put her house in her son's name. This was the house that she lived in, and she wanted to put that in her son's name, so she just wanted my help. And of course, knowing that that's why she had made the appointment in the first place, we had asked her to bring a copy of the existing deed on the property, and that way we could do up a new deed. Once I actually sat down with her, though, and we got to talking about this, she said, well, the property's not actually in my name, it's in my grandfather's name. Now remember, I'm talking to a woman who's in her 90s. And so she slides a deed over to me, and it's one that she's had in her possession for a long time, but this thing is dated in the mid 1800s, you know, where her grandparents acquired the property, and that is the last piece of the puzzle that exists out there. So in fact, when we looked it up on the tax rolls, it's still listed her her grandfather and her grandmother as their estates as the owners of this property. Well, you know, Lisa, the next thing I had to ask her was, well, how many kids did your grandparents have? And as you did at the time, you had a whole mess of kids because you needed farmhands.
That's right. So what, 8 or 9 kids?
I think there was 8 or 9 kids. Of course, her parent
was one of
those. But then, so the next question then I asked, well, how many kids did your parents, how many brothers and sisters do you have? And she said there was 7, 8 of them. So just within her one little line here, you know, when Grandma and Grandpa died, that property divided into 8 shares. Mm-hmm. When her parent died, that 8th share divided into 8 shares. So all she really owned was probably somewhere around an 1/8 of an 1/8 in this property. And as I'm trying to explain this, you know what her response was? But they're all dead.
Right. Right, that they're all dead, and as if that means they don't own anything or have any interest, or their heirs have any interest, which is not true.
That's right. What she had a hard time realizing was that every time one of these kids died, their share of that property, their 1/8 or 1/8 of an 1/8 or whatever it was, passed to their beneficiaries. And if one of those beneficiaries had died, their interest passed to their beneficiaries.
Well, and John, had this lady been living on that property by herself, paying the taxes, keeping the property up all of these years?
Oh yeah, in fact, this is the home that she had grown up in. She had grown up in this home after it had apparently been acquired by her parents, you know, and then that's where she was raised. They had died, she had stayed there, she had remained on that property. And in her mind, well, she paid for everything, she lived there exclusively. It's hers. In her mind, it was hers, and all she wanted to do was give her property to her son. But she didn't own it.
That's right. Wasn't as simple as that. So we're going to come back in a moment and talk about the challenge for this client to get the property into her name and then onto her son as she wished. And we're going to talk about some shortcuts that people take that turn out to be not so short by the time it all comes back around. So stick with us. We'll be right back.
Lone Star Truck Group is now hiring service technicians. We also have career opportunities in every department. With 23 locations across the South, work where you want. The best product lines in state-of-the-art facilities. Work with the best employees, receiving great benefits, competitive wages, and a safe, clean work environment. Receive ongoing product training for continuous career development. Contact Lone Star Truck Group today and recruit him at LoneStarTruckGroup.com.
Welcome back to Aging Inside. I'm John Ross here with Lisa Scholmeyer, and today we're talking about transitioning title to property, primarily real estate for today's purpose. And I started out by telling the story of an actual client who she was in her 90s, but what she claimed as her home and her land was actually just property that was originally owned by her grandparents, but no actual transfer had ever been done since their deaths. And by the time I got done looking at all of it and explaining the family, there were possibly hundreds of different owners to this one piece of land. And of course, her next response was, well, then what do we need to do to get it all into my name?
Right, okay.
You know, and I feel bad for the lady because she really doesn't understand. But the fact is that there is a process of trying to get a piece of property into somebody's name like that. It's what's called a suit to quiet title. And this is where you file a lawsuit. In the process of filing this lawsuit, you also have to notify all potential beneficiaries, which means we would have to go and trace all of the family trees from her grandparents, her parents, all of her aunts and uncles, all of her cousins, and all of their kids. And for every person that died, we would have to find out if they died with a will or without a will, if they had a spouse at the time of their death or not, if they had kids or not, and go through all of that and then notify. Once we had figured out this whole chain of all of these different people, then we've got to track all of these people down, notify all of these people, and just in case we might have missed some, the court is then going to appoint another attorney to represent any potentially unknown heirs. And so now she's got the costs of her lawyer, plus there's a court-appointed lawyer, plus locating all of these people, getting them served. And even if we had done all of that, you know, there's probably some of them that would say, oh, I don't care. Miss Ellie's been living out there. She can have my 175th interest in this property. But you know what, Lisa? There's always one.
That's right. When you notify someone that they might potentially be an heir in property, all of a sudden they figure that property was worth $1 million. And so there is always an heir or beneficiary that refuses to relinquish their interest, even though they have never set eyes on the property, even though they have never paid taxes on the property, or even though they've never maintained it or ever lived there. But the law says they are a part owner. So John, in that situation, if your client had gotten what we call quitclaim deeds from all the other beneficiaries except for one,
That's right.
if that one said, nope, I'm going to keep my 1/64th interest or whatever, then your client, lady, would not own that property outright free and clear.
No, she would just own
Most
of it.
Yeah, she would have a joint owner. And so a lot of families in our area, they refer to this type of situation as that they own what they call heir property, H-E-I-R, heir property, because they know they have an interest from a long dead family member, but they don't know exactly what it is, and nobody's ever done anything official. So heir property, for our viewers, is not a proper legal term of art. It is just a slang word, if you will, for this situation where you know you have an interest in property, but it hasn't been legally titled and determined.
You know, and so ultimately with this lady, what I had to tell her was that the costs were going to be so extreme that frankly it just wasn't worth it. The property itself was not valuable enough to justify all the cost it would take to do all of the work it would take to get that property into her name. And so ultimately she left my office with property that she doesn't really own all in total. And my guess is she's probably passed, since this was probably a decade ago.
Right.
She's passed. I bet her son is still living in that place, because that's where he lived. That's why she wanted to deed it to him.
Yeah.
I bet he's living there. I bet he's paying the taxes, and he doesn't own it either.
Okay.
And so, you just get this on and on and on and on. And if you let this go on long enough, then you can end up with essentially a worthless interest, because the cost to clear it up are more than what it's actually valued at.
Right. And so when I get a client that's in this situation, and that is not uncommon in our area, I think it may be a little more common, in rural areas where, people know who their great grandfather was and that they owned the 40 acres or 120 acres, and now the family has grown and dispersed. But usually one of the first questions I get in a situation like this is, well, if I paid all the taxes on the property all these years, isn't it now mine? This is a very common rumor that if you pay the taxes on the property, that you can somehow do that long enough to actually own the property. And the reality is that's not exactly true. As with many things, there's a little kernel of truth in this, but it's not just about paying the property taxes. In order for you to obtain property through this method, you have to do what we call adversely possess the property against all other owners and potential beneficiaries. Well, this means that you put a barbed wire fence up and you put a keep out posted sign and you tell all of your cousins and family members that they are not welcome on the property, and you would consider it trespassing. So essentially, you're saying you're a squatter on the property, and if you squat on the property, keep all the other family out, and then pay the property taxes, well, you might end up with a claim for ownership in the property. But John, the reality is, just like your client, I'm sure there were many family members who knew that that's where their aunt lived, that's where
right.
And they didn't care.
Right, so it's not adverse.
Right.
That's permissive.
That's permissive occupancy of the property and doesn't count toward building an ownership claim when we have all these different owners out there.
And when you want to file a claim for adverse possession, guess what you have to do? You have to file the lawsuit and then
notify everyone.
Notify everybody, and you're right back into the same sort of deal. So just the cost alone of that. So that's all how bad it gets, and what you need to do is fix it. And we're going to give you a few ideas of ways you can fix it, and some pros and cons with those when we come back from this next break. Stick around.
Lone Star Truck Group is now hiring service technicians. We also have career opportunities in every department. With 23 locations across the South, work where you want. The best product lines in state-of-the-art facilities. Work with the best employees, receiving great benefits, competitive wages, and a safe, clean work environment. Receive ongoing product training for continuous career development. Contact Lone Star Truck Group today and recruiting at LoneStarTruckGroup.com.
Welcome back, everyone, to our final segment on today's Aging Insight. And today we are talking about clearing title to property that may have been in the family. Maybe it's something that we call in our area heir property, where there has not been probates or any type of official title transfer on the property. And so in our earlier segments today, we talked about what a train wreck it can be and how expensive it can be to fix this issue. So now we'd like to talk about some solutions. So I guess the first solution, if you are knowing that this is your family situation, don't let it go on another generation. That's my first piece of advice. Stop it right now. And what this is going to take is it's going to take some legwork and some research and retaining an attorney to help you clear up the title on this property. Because the more generations it goes, the more people we have to involve and notify in order to get it cleared up later. So, if your parents never did anything and you and your brothers and sisters, you get along great and you split expenses and everybody goes out to the old family home place, we need to get something official and in writing regarding the title to this property, because while you and your brothers and sisters, the first generation past a death, might get along great and have a close relationship, it is less likely that the next generation, those children and cousins, they may get along, they may not. Some may move off to the big city and not, use this property. Others may use this property all the time. But the further we get from a death, the more difficult it gets to clear all this up. The court system allows for us to clear this up, first of all, through either a probate process, if the decedent left a will, and if the deceased owner of the property left a will and it has not been more than 5 years in the state of Arkansas or 4 years in the state of Texas, well, you may not have to do a full probate. You can do some shortcut procedures, but you still want to get something officially done so that you do have an official title for the property through a probate. But John, often in these cases, we are dealing with an owner of property that died more than 5 years ago.
That's right. And whether you had a will or didn't have a will, if it's been longer than 5 years in Arkansas or longer than 4 years in Texas, where you can't probate the will anyway,
right.
In these cases, you can still do, there's still a few other things that you can do. One is what's called a suit to determine heirship, a declaration of heirship. This is where you're filing with the court saying, we want something official to say, this person died, here's who their survivors are, so here's who everything passes to them. That often, that can at least clear that sort of thing up. I visited with somebody here recently, and so mom, there's 2 kids from the deceased, but there might be another kid out there.
Ooh, yeah, that happens sometimes
They're
too.
not sure, but there might be another kid out there. And something like the declaration of heirship, now we have a judge saying, here's who the heirs are. And you don't have this kind of up in the air of, who these people are and that sort of thing. When you do it through the court system, you end up with a court order, and that is about as solid as you can get.
Right, and so I know some of our viewers out there are thinking, oh, well, going through the court system, that's going to cost some money, it's going to be expensive. And John, I would refer our viewers to an episode before where we talked about doing either ladybird deeds or transfer on death deeds or life estate deeds, so you avoid going to the court system altogether. But in today's episode, we're talking about nothing was ever done.
That's right.
And so really, frankly, you don't have a choice. The longer you leave it, the more expensive and the more complex it gets for each subsequent generation. So, and John, we are talking about title to dirt.
Right.
And like I said, we don't make any more of that. So if anyone wants to build a house on that property, get a loan to remodel or upgrade any structures that are out there, even get agricultural type grants and things, you've got to show you have title to the property. So yes, getting a court involved there is a cost to that, but the benefit for the generation and the generations that follow is much bigger than the cost to get that title cleared up now.
But now, Lisa, there's some smarty pants that's watching right now.
I hope so.
And they're saying, well, we didn't have to do all of that because we did an affidavit of heirship.
Yes.
Now, for those of you who don't know what an affidavit of heirship is, this is a piece of paper that says this person was born on this date, they died on this date, and at their death they were survived by this spouse and they had these kids. And this is sworn to by 2 people who are not beneficiaries. Mm-hmm. And it's notarized, and then it's recorded at the courthouse.
Yes.
And this family that I mentioned earlier, where they've got the 2 kids and there might be a third out there, well, that was actually what they were coming in. That's what they were wanting.
Yeah, but someone told them to do an affidavit of heirship.
As a matter of fact, it was another lawyer that told them to do an affidavit of heirship, trying to save them a few bucks.
Right.
The problem is, think about it. Anybody anybody in the whole world could sign a piece of paper saying that they own your mama's house and get two of their buddies to sign that thing and get it notarized. And now all they need is $15-20 to go record that thing at the courthouse. It's just a promise from somebody. And now think about it. Maybe you're the person buying a house and you're looking at this piece of paper that two random people have promised that these are the only two kids.
Are you going to buy that house?
On that promise? Are you going to drop $200,000 on a couple of random people's promise that there's not a third kid out there? No.
Yeah, and banks and title companies, banks won't loan money on that affidavit of heirship, and title companies won't close a sale on an affidavit of heirship. Yeah. So it's not really a great option if we really want to get good, clear title to property. So I hope you've gotten something out of today's Aging Insight. If you are the beneficiary of some heir property where the title is not yet clear, give some thought to working on that project and getting it cleared up. So see you next week.
Bye-bye.
Why pay full price for steel? At Tri-State Discount Steel in Texarkana, you'll find thousands of shapes and sizes of surplus or used steel for half the price of new steel. Need steel tubing or pipe? We've got it. Steel gates, beams, angles, and diamond plate. Tri-State Discount Steel has that too. Every steel section for the professional and the home handyman. And if you need custom cutting or welding, our team is prepared to help you fabricate your project. Tri-State Discount Steel, 1701 East 9th Street in Texarkana. Lone Star Truck Group is now hiring service technicians. We also have career opportunities in every department. With 23 locations across the South, work where you want. The best product lines in state-of-the-art facilities. Work with the best employees, receiving great benefits, competitive wages, and a safe, clean work environment. Receive ongoing product training for continuous career development. Contact Lone Star Truck Group today and recruiting at LoneStarTruckGroup.com.